Desley here, and today I'm going to be talking about sections 28 and 29, consultation between employers and employees under the Contract Call Centres Award 2020. So let's begin. So section 28 deals about consultation about major workplace change, and 28.1 states if an employer makes a definite decision to make major changes in production, program, organisation, structure or technology that are likely to have significant effects on employees, the employer must give notice of the changes to all employees who may be affected by them and their representatives, if any. For example, they need to give notice, which really should be in writing, to all employees affected by the changes and their representatives, i.e. their union officials, or in the case of teenagers under 18, to their nominated parent to review and look at the changes. Now, changes can be in many shapes and forms. For example, in one business, the employer in the call centre, brought in a system of gold, silver and bronze, and basically each week they determine through call monitoring and other stats that they collect on the employee whilst on shift as to whether they will be categorised in the gold, silver and bronze. It doesn't sound like much, although in one sense it could be a sense of bullying by the employer, which is dealt with under the Work Health and Safety Act, so I'm not going to go into that here. In another sense, it could also be that down the track, the impact on employees is such that they might have their shift hours reduced or actual rostered shifts taken away from them. So I'll use that example all the way through, just to give you an indication how one decision by an employer can have a major impact on employees down the track, and really should be consulted because it is a major change within the company that ultimately has impact on the employee. And the employers need to discuss with the affected employees and their representatives the change they want to bring in and what the potential impacts are. If we look at 28.1 in the subsections, it says they need to consult and discuss the introduction of the changes and their likely effect on employees, as in the example I have given you, particularly for casual employees, how many hours or they undertake in a rostered shift day or evening or afternoon or night, or actually they might not even receive their normal rostered hours for the week. They might lose a shift or two, or might receive no shifts at all. The employer also needs to discuss and put in writing any measures to avoid or reduce the adverse effects of the changes on employees. In other words, what strategies is the employer going to put into effect to make sure that the impact on employees, both as individuals or as a collective, are reduced, the impacts are reduced as a result of bringing in these changes. And under the Act, Clause C of 28.1 says the employer basically needs to commence these discussions as soon as practical after a definite decision has been made. Now, that basically means that they might be talking about this amongst the management team for quite a while, but once they make a definite decision that this is the way they want to go, then they actually need to discuss with employees the decisions that they want to bring into place and what the impacts are, as well as the strategies to avoid or reduce any sort of adverse impacts of the changes they want to bring into the workplace on the employees. For the purposes of the discussion, giving the information on the impacts and the strategies, etc., the employer must give in writing to the infected employees and their representatives, i.e. their union officials and or delegates, all relevant information about the changes that they want to bring in, including their nature, so what is the actual change, and their expected effect on employees, and any other matters likely to affect employees of the change they want to bring in. So this is really, really important, because sometimes employers bring in decisions and change workplace and they don't seem to think that they need to consult with employees before bringing in the change. Maybe they haven't discussed all the ramifications themselves within the management team as to how employees are likely to take the change, or had a discussion on what the impact would be for employees. Maybe they've just ignored this section of the Act. There could be a number of reasons, or it might have been seen as a minor change, which subsequent decisions then turn it into a major change, major impacts for employees down the track. And the classic example is of the gold, silver and bronze criteria that the employer was using in the workplace, basically to determine what level. So from an employer's perspective, it may be, we're bringing in this so we can encourage staff to do better. However, and that might have been their initial idea, who knows, because it wasn't consulted with the employees. It's very hard to determine, look back as to what the employer's thinking was in regards to bringing in that change. Now, that might have rocked along for a little while, and then suddenly the management team of the company thought, oh, we can use this as a way of determining who, for our casual staff, of who gets shifts and how many hours. Now, that then makes the decision a major impact, because it's actually then having a impact on the employees' livelihoods, and they needed to put it in writing. Now, there is a slightly get out of free jail card for employers, particularly with casual staff in clause 28.3, that basically the employer is not required to consult or to disclose any confidential information in its disclosure that would be contrary to employers' interests. Again, it's catch-22 in many respects. The employers could say, well, it's not based on the gold, silver and bronze status rating that you receive each week. It's basically for, if we say in current times, it's because of COVID. We're not liable to disclose our business information to employees about how much money we're getting or not getting as a result of COVID. And in this particular workplace, the employer or management team have given quite a different reasons to different people, either verbally or in writing, as to why their shifts have been reduced. For example, it's been because you haven't performed well in the gold, silver, and bronze rating. It's been one. Another has been, oh, it's because of COVID, which made it really strange. Another reason that has been given is the wages budget has been reduced, and yet the employees have also noted, if the wages budget has been reduced, then why are they employing new staff rather than giving the hours to their current staff? So again, some employers will use this get out of free jail card, thinking that it means that they don't have to consult, or they don't have to disclose their real reason as to why they're bringing in a major workplace change. I don't think any employees want to know exactly what the budget is for the wages or what their overall income is. But staff are not silly at the same time. They can see through some of these pathetic excuses when employers are really trying to dodge their legal responsibilities under the Act. And in 28.4 of the consultation of major changes, the employer must promptly consider any matters raised by the employees or their representatives about the changes in the course of the discussion. So in other words, it's not just, oh, we've consulted with our employees by saying, this is the change, we're going to do it, suck it up, and that's it. They basically, under the Act, under this clause, have to start listening and taking on board what the actual employees are saying, particularly about the impacts of the proposed change or changes as part of the discussion. If they can't show as an employer that they have done that, then legally they're on very thin ice and could be successfully argued in a court of law that they literally did not take on board or listen to what employees were saying about the impacts of these changes. In 28.5, particularly about the significant effects in section 28 on employees, it also includes what they need to take on board, or any changes include termination of employment, or major changes in composition or operation or size of the employer's workforce, or in the skills required or actual job skills required. Basically, talking about the same workplace, some employees have noted, for example, that there's been a major change on how the calls are diverted to an overseas country, gives two rings, and then it goes diverted to overseas. So the employer has actually beefed up the overseas workforce as opposed to the Australian workforce, and for that's a major change in the composition of the operation or size of the employer's workforce. So they need to consider, nobody's saying that the employer can't beef up their operations overseas. That's not the argument. The argument that could be put forward is, well, yes, okay, you've made this major change on the call receiving process that is having a direct impact on the Australian workers. And also, C is loss or reduction in job or promotion opportunities, and D is loss or reduction in job tenure or alteration of hours of work. Now, this is where it does become very important for any employer to, when they're considering of extending their or expanding their workforce overseas and potentially reducing their workforce in Australia, even with the alteration of hours of work, that they need to consult with employees about the change they're doing. And the need for employers to be retrained or transferred to other work locations. Now, it may be that people can't be retrained, or they might have to be trained up to different skills level, and that's really the onus is on the employer to discuss that with employees. If they can be transferred to other work or other locations, then that also needs to be discussed. But if, for example, this employer has 3 Australian workplaces in 3 different states, it may not be that employees can be transferred to another work location. And the other NG is restructuring. When you look at it, it's quite extensive what the consultation process that employers must undergo with employees, because it covers quite a lot of different areas. Can't just say we're bringing in this change, for example, and we've decided that based on your rating of gold, silver or bronze, if you're bronze, for example, you're not going to get any shifts next week. A, that's an alteration of hours of work, but B, that actually affects employees' livelihoods. Or alternatively, we'll give you a shift, but we'll only give you 4 hours for the week. Again, that's affecting people's livelihoods. Now, in this particular call centre, it's always been known that the winter months are the quieter months, so people, particularly the casual staff, do get less shifts. However, this year, 2021, the alteration of work hours has been quite extreme. Trying to drill down as to what the employer is doing and why and how they're determining their decisions has been a major exercise for the employees, and haven't still got there as yet. In 28.6, where the award makes provision for alteration of any of the matters defined in 28, such alteration is not taken to have a significant effect. In other words, if there's another section of the award that may cover that, it's not considered to have a significant effect. They may not need to consult as widely as they might do. Section 29, consultation about changes to rosters of or hours of work. This is another interesting aspect of the award, which is very handy to know, is that this section applies if an employer proposes to change the regular roster or ordinary hours of work of an employee other than an employee whose working hours are irregular, sporadic or unpredictable. Now here again is another little get out of free jail card kind of for the employer. And what this particular employer has undertaken is, over the course of winter, has chopped and changed the roster to now the working hours are to such an extent that the working hours for most of their casual employees, particularly in one location, are irregular, sporadic or unpredictable. It's very interesting how they're doing this, but again, it seems like a get out of jail free card, except for 29.2, the employer must consult with any employees affected by the proposed change and their representatives, if any. On one hand, it says, okay, so you can change the roster and everything like that. Casual work is casual work, you're a casual. However, they can't make the change so drastically like they have done based on their decision to determine who gets hours, how many hours or how many shifts, based on this gold, silver, and bronze rating. So again, they still must consult with the employees and or their union representatives or union officials and put it in writing. Again, they still have to consult, which this company has not done. Again, it says the employers must provide the employees and representatives information about the proposed change. For example, information about the nature of the change and when it's to begin. So in other words, they just can't make the decision and say, guess what, this is what we're doing, bang. And they need to invite the employees to give their views about the impact of the proposed change on them, including any impact on their family and caring responsibilities. And they also must invite their representatives, if any, to give their views about the impact. So again, they need to consult. And again, 29.4, the employer must consider any views given under clause B, which is what the employees are saying. There is a rider here that clause 29 is to be read in conjunction with any other provisions of this award concerning the scheduling of work or the giving of notice. You need to read it all in conjunction with each other. And sections 28 and 29 specifically deal with major changes that the employer makes in the workplace, and those changes may creep up on over a period of time, which is basically what has happened in this workplace. First off, they brought in the gold, silver and bronze, then they brought in what they call a BTP status, which nobody fully understands how they calculate, and then they added those together, and that then gives you the gold, silver and bronze, or they had to call monitoring anyway, and they added the BTP status to it, and that's when they determine how you get the gold, silver and bronze rating as such, and how many mistakes you make or haven't made. And it's very, very unwieldy and very, very confusing. Not to mention, they have clearly, particularly the past month or two, have now determined that depending on what rating you have received for the week for the individual employee will depend on whether you get a shift or not, even shifts for the week, or whether your hours are further reduced or you actually not even rostered on as you normally would be, even through the winter months. You can look up this yourself. I'm going to leave this video at this point only because I want to deal with part 2 in it, which deals with individual advocacy or individual employees and consultation, and what the employees' rights are and what the employer responsibilities are, in a totally separate video as part 2. Again, I will leave the link that you can refer if you want to look at the Act itself, or you think of other ideas that can be included. That would be good, and I'll leave it there. Thank you. Bye for now.